The Supreme Court just dropped a 90 unanimous ruling that nobody is talking about, and it changes everything about how police can take your guns. 9 justices, 0 disagreement. That almost never happens in a court as divided as this one. This ruling strikes at both the Second Amendment and the Fourth Amendment at the exact same time, which means your right to keep your guns and your right to be free from illegal searches just got a massive boost all at once. If you own a firearm, if you keep one in your home for protection, you need to stay right here because this affects you directly. The case is called Caniglia v. Stroh, and the Supreme Court of the United States decided it on May 17, 2021. For years before this ruling, police departments across the country were using something called the community caretaking exception to walk into people's homes and take their guns without a warrant. That phrase sounds harmless enough, but it had quietly become a backdoor tool to strip gun owners of their legally owned firearms with 0 judicial oversight. And the highest court in the land just shut it down completely. 9-0. No dissent, not a single justice. Disagreed. The information I'm about to share could literally save your guns the next time police show up at your door. But first, are you subscribed? You're going to want notifications turned on for this one because legal updates like this are dropping constantly and you do not want to miss them. Tap that subscribe button right now before we go any further. Now let me tell you the story of Edward Caniglia because this case started with a real man in a real home on a real night, and the way it unfolded will genuinely make your jaw drop. Edward and his wife had a serious argument inside their home in Cranston, Rhode Island. Things got heated, emotions were running high, and Edward did something dramatic in the middle of the fight. He grabbed one of his handguns, put it on the kitchen table, and said to his wife, "Shoot me now and get it over with." Edward did not shoot anyone. Nobody got hurt, but his wife was frightened enough that she left the house that night, stayed somewhere else, and called police the following morning. When officers arrived, they assessed the situation and decided they needed to check on Edward's welfare. They spoke with him, brought him outside, and made him a deal. They told Edward that if he agreed to go to the hospital for a voluntary psychiatric evaluation, he could come back home afterward and everything would be fine. Edward agreed. He thought he was doing the right thing. He thought he was cooperating and that his cooperation would be respected. He got into that ambulance and went to the hospital, believing his home and his property would be waiting for him when he returned. Here's exactly what happened while Edward was gone. While he was sitting in that hospital doing exactly what police asked him to do, the officers went back to his home. They went inside without a warrant. They located his firearms and they took them just like that. When Edward came back home after his evaluation, which found nothing wrong with him, he asked for his guns back. Police told him they couldn't return them. He had been lied to. He had cooperated in good faith and got deceived in return. His legally owned property was gone, and nobody had ever asked a judge for permission to take it. That's when Edward Caniglia did what every American should do when the government crosses the line. He fought back in court. He sued the police officers in the city, arguing that entering his home and seizing his guns without a warrant was a clear violation of his Fourth Amendment rights. The Fourth Amendment is the constitutional protection that shields you from unreasonable searches and seizures. In plain, everyday English, the government cannot walk into your home and take your belongings without first getting a warrant from a judge. Edward's case was straightforward. No warrant was obtained, no judge approved anything. Police just walked in and took his property. Pause for a second right now. Do you think this ruling goes far enough to protect gun owners? Drop your answer in the comments below and tell me what you think. And while you're down there, smash that like button because it helps this information reach more gun owners who genuinely need to hear it today. The police in the city tried to defend themselves in court using a legal doctrine called the community caretaking exception. That's a legal phrase. So let me break it down for you right now in the simplest possible terms. Back in 1973, the Supreme Court decided a case called Katie versus Dombrowski. In that older case, the court said that police could sometimes search a vehicle without a warrant when they were acting as community caretakers, meaning they were trying to protect public safety rather than investigate a crime. Think about a situation where a car breaks down on a highway or an abandoned vehicle is blocking traffic. The idea was that cops shouldn't need a warrant every single time they open a car door for safety reasons. That logic made sense for vehicles on public roads. But here's where the trouble started and where it grew for decades. Police departments around the country took that car rule and decided to stretch it all the way to people's homes. They argued that if officers believed someone inside a home was in danger or might be dangerous to others, they could enter without a warrant and seize property, all under the banner of community caretaking. Lower courts in multiple states allowed this argument to stand. Gun owners had their firearms taken during mental health calls, during domestic disturbance calls, during neighbor complaint calls. There was no judge involved, no warrant signed, just an officer making a personal judgment call and walking out of your home with your guns in hand. Here's what this means for you personally, and this is the part that matters most in this whole video. The Supreme Court in Caniglia versus Stum said clearly and unanimously that the community caretaking exception does not apply to the home, period. Justice Clarence Thomas wrote the majority opinion and all 9 justices signed on. They said the home has always been the most constitutionally protected space under the Fourth Amendment, going all the way back to English common law before America even existed. Your home is not a car on a public road. It cannot be treated the same way, and police cannot invent a new excuse to skip the warrant process just because they think it would be easier or faster. This ruling draws a hard constitutional line right at your front door. So, what does this actually look like in your life starting right now? If police show up at your home because a neighbor made a call or a family member expressed concern, they cannot walk inside and take your firearms just because they believe you might be upset. Even if they say they're just checking on you, even if they claim they have good intentions do not override your constitutional rights. You have the right to refuse entry. You have the right to tell them politely but firmly that you don't consent to any search, and that if they believe they need to enter, they need to go get a warrant first. That right exists today because of this ruling. This is like the difference between a friend knocking on your door and a stranger kicking it in. The knock you can answer or ignore on your own terms. But the moment someone walks inside without your permission and without a court order, they have crossed a line. And the Supreme Court has now confirmed with every single justice agreeing that crossing that line without a warrant is unconstitutional. Knowing that line exists changes everything about how you respond when police show up at your door for any reason that isn't a clear and obvious emergency. You are not powerless. You now have the full weight of a 90 Supreme Court ruling behind you. In just a moment, I'm going to reveal something about this ruling that even most gun rights channels and most Second Amendment advocates are completely overlooking. But first, are your notifications turned on? Tap that bell right now because the follow-up content on this topic is going to get even more specific and even more useful for your real-world situations. Let's talk about what this ruling means for the future. Because most people hear a court decision and think it only affects the one person in the case. That thinking will cost you. Caniglia versus Stum sends a direct signal to every police department, every city attorney, every district attorney, and every state legislature in all 50 states. The signal is this: if you want to take firearms from someone's home, you need to go before a judge. You need to show evidence. You need to meet a legal standard. That process exists for a reason. And this court just said you cannot skip it. That creates accountability where before there was almost none when it came to warrantless seizures in the name of wellness. Here's what most people are missing entirely. Lower federal courts and state courts are now actively revisiting cases where guns were taken under the old community caretaking logic. People who had their firearms seized during welfare checks or mental health calls years ago may now have legal grounds to challenge what was done to them. It won't be automatic. It won't be easy. But the legal door is open in a way that it simply wasn't before May 17, 2021. If you or someone you know had guns taken during a police wellness or welfare check without a warrant, this ruling is the starting point for a conversation with a Second Amendment attorney. There's also something bigger happening here that directly connects to state red flag laws. Red flag laws, which are sometimes called extreme risk protection orders, allow a court to order guns removed from a person's home based on a petition, usually filed by a family member or law enforcement officer. These laws vary significantly from state to state. Some have strong due process protections built in, meaning you get a chance to respond before your guns are taken. Others are much weaker on that front. Caniglia does not strike down red flag laws directly, but it makes it much harder for anyone to argue that police can skip the court.